Good morning. Today, we're going to discuss criminal rights. To start, we have to look at the Due Process Clause. It's important to note that we're not just talking about criminal rights here, we're talking about the rights of students, the rights of employees, the rights of any number of groups. The idea is that there are a certain number of things that has to happen before an employer, before a school administrator, before law enforcement can take those rights away from you. Now, you can see here that the Fifth Amendment protects your rights at a federal level. But it wasn't until the 14th Amendment was ratified in 1868 where the courts could start to interpret your rights at the state and local level as well. So the Due Process Clause of the Fifth and the 14th Amendments are absolutely critical to you having those rights. Now, a part of that is separating the different types of due process. There is procedural due process that deals with the steps that the employers, that law enforcement, that take before they start taking away certain rights or privileges from you. But then there's also substantive due process, and that's a lot more controversial. And the reason why is that involves the fairness of the laws themselves, whether or not this is a law that should be in place. A case that filed under that specific type of due process was Roe v. Wade. We'll get to that a little bit later. A key part of the rights of the accused is the Fourth Amendment. And believe it or not, as students even, you have Fourth Amendment rights. The key part that I want to hone in on for you is unreasonable searches and seizures, okay? And that no warrants can be issued without probable cause. Just this past week in my California Ed Law class, one of the things that the professor brought up is that schools have to be very careful in how they approach searches with students. You don't have the same rights as you would out there on a public street, but you do have due process rights related to the Fourth Amendment, and that's worth noting. Michelle Alexander and the new Jim Crow certainly called to question some of those rights, particularly for minority groups, and I think that some of that skepticism is warranted. Now, police officers utilize different kinds of cause, though, and again, that's something that Michelle Alexander spoke about in her book. There's reasonable suspicion that's held at a much lower standard, and probable cause. Probable cause is a much higher standard. Now, what's also worth noting is that your Fourth Amendment rights in your car are not quite as protected as they would be in your home. Even with scales of reasonable cause versus probable cause. And that's worth noting as we take a look at Mapp versus Ohio. This is an absolutely critical case because it involves what came to be the decision that happened here, which was the exclusionary rule. In other words, the police officers kind of stormed into this woman's house, kind of faking that they had this warrant. They didn't have a warrant. When the woman asked for it, they attempted to play coy with her. And when they kind of tried to fake hand it to her, she ended up taking it from them and hiding it. And it turned out to be a faulty warrant. And when it was challenged in the courts, it held. And the evidence that they ended up finding, which was pornography, not the bombs that they'd initially been searching for, the courts threw out that evidence and they established something called the exclusionary rule. In other words, any evidence that's found in a search that's done unlawfully, without probable cause, without a warrant, that evidence cannot be used in a court of law. You can imagine that a number of criminals began challenging their cases, and a lot were freed because of this exclusionary rule. So once this case happens, it really opens the floodgates for many criminals to start challenging their cases, not just here, but in a number of other areas too, some of which we'll be discussing here shortly. Now, the USA Patriot Act is quite significant when we look at something like the exclusionary rule or the protections against unreasonable searches and seizures, because it grants the federal government vast capabilities to use things like roving wiretaps, using things like we saw with the Edward Snowden case, mass surveillance. And these are obviously done without warrants. These are obviously done without probable cause. But the question is whether or not they were necessary steps in order to keep the nation safe. I'll let you make some decisions there. Obviously, it's challenged on a number of key grounds, and these warrantless spying is a big part of that. Next, I want to take a look at the Fifth Amendment. The big one that you typically hear about is double jeopardy, meaning you can't be tried for the same crime. The self-incrimination clause, meaning that you have the right to remain silent, even up on the stand. You have to be quite careful with that, but these are key protections there. Recognize again, we're looking at that due process clause. The Fifth Amendment protects that at the federal level. Again, the 14th Amendment extends it to state and local. Eminent domain is a relevant factor as well. And just to point out, the federal government or state and local governments have the right to utilize the property that you are currently residing in your home if they provide fair market value and they can use it for some sort of public use. But again, you have due process rights to those properties. But these are some of the other protections under the Fifth Amendment. Another relevant case here, one of your landmark cases, goes a little bit further than that, and that involves what kind of rights you have to a speedy public trial. I hope you know what amendment I'm referring to here. This was a gentleman that attempted to challenge his detention, or excuse me, his conviction, because he could not afford an attorney. Now, the Sixth Amendment had already been extended to the federal government at this point. In other words, if you were convicted of a crime, or excuse me, if you were without an attorney facing a federal charge, you could ultimately have an attorney appointed to you. But that was not a selectively incorporated right yet. It wasn't until this case that the court determined that you had a right to an attorney at the state and local level. I want you to think about what kind of impacts that's going to have on states, because this is ultimately a mandate of the federal government, an unfunded one at that. But this is considered a landmark case as far as criminal rights are concerned, because ultimately it didn't distinguish between the haves and have-nots. Now, granted, Michelle Alexander calls to question just how practical this is and how many loopholes there are with providing these protections, but it is worth noting that this case did create those protections. Where some of those right to trial issues came to the fore was cases in the War on Terror. There were cases like these with Hamdan v. Rumsfeld that dealt with whether or not the federal government could utilize something that are called military tribunals. Now, it's worth noting that the Sixth Amendment specifically states speedy public trials. But with military tribunals, that isn't always the case. With a military tribunal, it is in secret. It is happening among the military. Military staff provides the judge, they provide all the staff within the court, and they provide the jury itself. So this is not a speedy public trial, but the executive branch under George W. Bush indicated that they had every authority to do that. Moreover, beyond the speedy public trial aspect, there were other things about the indefinite detention of the accused. In other words, some of these folks, guys, like the Padilla case, they did not face a trial for 3 years. So not only are they not being formally charged before a judge in some cases, they're not facing a trial for up to 3 years as well. All this came to the fore during the War on Terror. What I hope you can begin to make some comparisons to is some of what you may have learned in your U.S. history class, and that is about the detention of the Japanese. One case that you typically don't hear about, though, is Ex parte Endo. Now, you've heard about Korematsu and you've heard about Yasui in some cases. But Mitsuye Endo, one, she's from the Sacramento area that I think is quite relevant here. And two, the other factor that I think is quite important here for you to kind of register is the fact that she was challenging her detention. In other words, she was saying that her habeas corpus rights had been denied to her. And just to relate back to what the habeas corpus rights are, is that remember, before you even go to trial, you have to be charged with a formal crime. Okay? The Japanese were not charged with a crime during this case in nearly any circumstances among the 110,000 people among them. So when she challenged her case and ultimately reached the U.S. Supreme Court, they did determine by 1945 that Endo, who had been loyal throughout this entire process, was being unlawfully detained. Now, it wasn't until fairly recently where the U.S. government began to question the detainment of the Japanese. And you can imagine that some of that, again, came about because of the War on Terror. Now, here you can see that some are justifying the treatment of some of the alleged terrorists on the grounds that the racial profiling used during World War II was justified. I'll let you make some decisions on that. But again, these issues aren't going away on that. You can imagine the next time some international conflict comes up with a targeted nationality, this issue comes up to the fore again. What constitutional rights will be provided then? We know that during war times, liberties become diminished. But to what extent do we allow that? And do we allow that to happen to certain groups but not others? Keep those questions in mind. The final right that I want to take a look at here, guys, or liberty, excuse me, is the Eighth Amendment. I didn't look at the Seventh Amendment because anymore it's largely obsolete. I'll let you take a look at it to determine why, but really every case is applicable to the Seventh Amendment, so I'm not really going to look at that one. But the Eighth Amendment is relevant here, guys, because of things like excessive bail shall not be required. But the one that tends to be quite a bit more controversial is this, nor cruel and unusual punishments inflicted. Now, as you can imagine, much like other parts of the Constitution, that is widely interpreted of what constitutes cruel and unusual punishment. Again, we look at the War on Terror to kind of look at some of those questions. Okay? There were some within the Bush administration that were arguing that the only things that constituted torture were things that brought about total organ failure. Now, that was an interesting interpretation on that. And you can see here that there are these notions of how much pain and what can be gained from that. You typically hear these scenarios about, well, what if we could torture this person and yield information that could save hundreds? That may be, an important question to ask, but the question that you need to ask before that is are these alleged terrorists warranted Eighth Amendment protections on that, protections from cruel and unusual punishment? Now, the death penalty obviously comes up in this as well, and I'll let you take a look at Gregg v. Georgia here. The U.S. Supreme Court has obviously supported the U.S. death penalty. Their questions aren't about whether the death penalty is typically committed, but how it is committed. California has been engaged in the use of lethal injections, but many pharmaceutical companies have stopped producing the chemicals used for the chemical executions, and it's harder and harder for states to acquire that. That, as well as a number of other reasons, prompted Governor Newsom to issue a moratorium on the death penalty. The problem with that is shortly before Governor Gavin Newsom made this decision, the state of California, through a popular initiative, indicated that they still supported the death penalty. So he made kind of unilateral action there. So it will be interesting to see how the courts rule on Governor Newsom's action. I want to end our discussion here by taking a look at the death penalty today. You can see that the majority of the states do allow that, but most nations do not use the death penalty anymore. And whether or not that's a relevant point to you is up to you to determine. But what I do want you to think about is some of the questions surrounding the constitutionality of the death penalty. What constitutes cruel and unusual punishment? And whether or not these international comparisons do matter. Thanks for the time, everybody. I appreciate you taking a look at these issues with me in depth. I have a lot of fun with it, and I hope you do too.